Hello everyone, and welcome to our short webinar on what does GDPR mean for B2B marketing data from Experian Business Assist. I'm Jo Shaw, I'm a marketing manager at Experian, and today with me is Richard Leonard, our Head of Data Partnerships and Regulatory Affairs.
Thank you, Jo. So we only have a short time, and of course the General Data Protection Regulation, or GDPR, is a vast subject. So I'm going to focus on the key points to give you the assurance of why you can continue to use B2B marketing data from Experian Business Assist. So, what is GDPR? What's it all about? Well, the data protection framework in the UK, and indeed across Europe, was established at a time when people had less of an online presence, before the loyalty card was prevalent in the retail industry, and when people were often still managing their data in very manual ways. And of course, as we turned digital, there was a radical shift in the volume, variety, and the speed data was produced. So the GDPR is agreed as an EU regulation. So when effective, it will apply automatically and equally in all member states. And that's important because currently, companies operating across Europe have to comply with 28, often very different laws. And also the GDPR is a real desire to strengthen consumer rights, particularly online, in reaction to the activities of social media companies and search engines. And the GDPR is all about building a new gold standard of data protection and making data protection in Europe fit for the digital age. So it's been passed as regulation, and it will become effective on May the 25th, 2018. So to paraphrase the Information Commissioner, the GDPR is not a box-ticking exercise. This is a cultural shift throughout the entire organisation, and indeed every organisation. However, we should see the GDPR as an evolution, not a revolution. It doesn't throw away all the good fundamentals that businesses will have in place today around the 8 data protection principles and the Data Protection Act, but it's about making sure those principles are built upon and taken into account by organisations from the start. And indeed, those 8 data protection principles are all a little bit tighter and higher standards required. Now, the GDPR does introduce what you could call 2 new principles, and they are transparency and accountability. So transparency is also known as the right to be informed. Now, this emphasises openness about how you use personal data. So this is typically done through a fair processing notice or a privacy notice. And certainly at Experian Business Assist, we're updating all our privacy notices, and we've written a clear guide on how we process personal data for marketing use, and we'll make this available on our website. Now, the other fundamental is accountability, and the GDPR explicitly says that organisations must be able to demonstrate compliance with the regulations. So this means doing things like documenting your processing activities, organisation design, and where appropriate, appointing a data protection officer. Now, there's a new expanded definition of personal data. So this is any information that relates to an identified or identifiable natural person. And it's introduced some new identifiers which can be used to identify someone, either by itself or in conjunction with another piece of data. So obvious things like names, date of birth, but now online identifiers like IP addresses can identify a data subject. Then any data attached to that subject is classified as personal data, such as email addresses, loyalty card data about shopping habits, bank details, etc. There are also special rules to follow in order to process what we call special categories of data, such as religious beliefs and health information.
So Richard, how does this relate to B2B marketing data?
Well, in our world of B2B marketing, personal data refers to contact names, addresses, telephone numbers, and email addresses. And in particular, any data on non-registered businesses is classed as personal data.
But surely, if they're operating as a business, that can't be personal data?
Well, now this may be data about someone operating in their business capacity, which may be far less sensitive than their personal shopping habits and bank details. But nonetheless, this is personal data, and so it does fall within the scope of GDPR. Now, I want to introduce the concept of legal basis of processing, the whole consent versus legitimate interest basis. So you have to have a legal basis to process personal data, and there are 6 legal bases available to cover all types of legal processing. Now, they're all equally as bad as each other, so there's no hierarchy, there's no one better than the other. But the 2 that are most talked about in the context of marketing are consent and legitimate interest. So traditionally, marketing activity has been done on the basis of consent, but the GDPR has introduced the legal basis of legitimate interest and has specifically mentioned its suitability as a basis for processing personal data for marketing. But the important thing to remember here is that legitimate interest is not it's not a get-out-of-jail-free card, as you can only use your legitimate interest to process the data if you can demonstrate that such interests are not overridden by the interests or the fundamental rights and freedoms of the data subject. So let's have a look at Experian Business Assist legitimate interest. So our legitimate interest is the provision of targeted B2B data for the purposes of direct marketing and sales to providers of B2B services to enable the commercial and economic interests this activity supports. And as we mentioned, to establish a legitimate interest, you have to show how you balance the interests and rights of the data subject with the interests of the controller and indeed our clients. So one question to ask is, would the subject reasonably expect the processing to take place? So the answer here is yes. Businesses make their details public on websites and public directories, and so would expect to receive some communications. And actually, as a business themselves, they probably engage in some sort of marketing activity themselves to grow or maintain their own business. So here, the ultimate aim is to ensure that businesses receive communications about B2B products and services they may wish to buy, and that suppliers who can deliver those products and services communicate with those individuals. And we believe that is clearly in the interest of the individual. So if we look at how we make this balance between the data subject's interests and our interests, so the data subject receives offers for relevant goods and services. We do that by ensuring that modelling and selection criteria make the proposals relevant, make the targeting relevant. So let's talk about the National Business Database. So this database is legitimately built from a variety of data sources. So there are public sources like Companies House, and these sources operate or process their data on one of the 6 legal bases of public interest or exercise of official authority. We then have some marketing directory suppliers, and they operate under legitimate interest. And in doing so, their model is they will have called all the businesses in their directory to verify the business details and give the data subject the correct notifications of processing, and they explain their legitimate interest in their transparency notices. And then we have some further niche providers who also operate on the basis of legitimate interest. Now, there's another piece of legislation we need to be aware of. So the Privacy of Electronic Communications Regulation, or PECA. So PECA is still the law, and this extends the obligations of the current data protection law, and this covers electronic marketing communications. So PECA is still the law, and it will be so until it's replaced by the e-privacy regulation, which has been worked on in Europe now, but not expected to be finalised for many months yet. So by reading the GDPR and PECA together, it can be understood that it's not possible to process data on the basis of legitimate interest if consent is required under PECA. So what does this mean? Well, PECA deals with electronic communications, so we're talking telephone, text, and email. So we don't provide numbers for text, as we've always felt that's too intrusive. But telephone, well, telephone marketing is allowed as long as the subject is not registered under the Telephone Preference Service or the Corporate Telephone Preference Service. But that excludes automated dialing. Now on emails, emailing personal corporate email addresses, such as joesmith@abclimited.com, is okay on an opt-out basis. But emailing a non-registered business, so a sole trader, for example, requires consent, because as we said right at the front of this talk, under the definition of personal data, a non-limited business counts as personal data because it's operating, the individual's operating in that business. So, under GDPR, there are enhanced requirements for consent, and this means that for non-registered businesses, consent is required for the named sender of that email. So we've concluded that it's not possible for our third-party suppliers to properly capture consent on non-registered businesses to the full extent required by the GDPR. So at this time, we're no longer able to supply email addresses of non-registered businesses.
So Richard, can you explain a little more about what types of email addresses this affects?
Yes, sure. So let's be absolutely clear about this. This only affects emails being sent to non-registered businesses, so sole traders typically, so Joe the plumber. This doesn't affect emails to limited companies, which can still be sent as long as it's on an opt-out basis, i.e. you give the receiver the option to opt out of future emails.
Thanks, Richard. So having heard all of what you've said, can we conclude it's still safe and legal to continue to use marketing data from Experian Business Assist?
Yes, you can be absolutely confident that the data has been sourced legally and under a solid legal basis for processing, i.e. our legitimate interest. But as a marketing manager, you now need to process it legally. So this means establishing your own legitimate interest processing, and you can help support this by ensuring your prospects have a relevant interest in your products and services, and only communicate about relevant business-to-business products and services. Only send relevant communications to the appropriate audience. Be as targeted as possible. Use B2B prospectors segmentation criteria. There's 150 different criteria to segment by and really get that targeting right. Then remember, it's really important to uphold the rights of data subjects. In particular, remember that every data subject has an absolute right to object to their data being used for marketing, so you must allow for this to happen. And then follow the DMA code of practice. Make sure you clearly name yourself, make sure it's a relevant offer, and make sure there's that unsubscribe option. That way, you can confidently continue to use B2B marketing data from Experian Business Assist.
Thank you, Richard. That's really helpful. So everyone, that concludes our webinar. Thank you for listening. If you'd like to find out any more about B2B marketing data from Experian Business Assist, please go to www.b2bprospector.co.uk. Thank you.